Executive Director at Cape Assist, our sponsor today, for working with us to put together our program. And Katie, as our moderator, will introduce our speakers. Katie?
Good morning, everyone. Thank you so much for attending today. Cannabis in the workplace is a topic that I think is going to affect all of us greatly over the next season and then beyond. There's still a lot to unpack from the law and that needs to be determined. And I'm thrilled as an employer to hear more about this issue today. And let me introduce our two speakers, Brittany Benetti. Brittany is an associate in the Cooper Levinson's Healthcare and Cannabis Law Practice Groups. She assists hospitals and health systems, medical staffs, individual physicians, and physicians groups in business and regulatory legal matters of all types, helping them navigate complicated healthcare regulations such as stark, fraud and abuse, anti-kickback, and state regulatory concerns. Brittany is going to provide us with an overview of the cannabis law, the industry, and how it has come to fruition, not only in New Jersey, but some other states across our nation. So we can sort of compare what we have with other states. Next is Amy. Amy Rudley is a partner in the Employment and Labor Law and Hospitality and Casino Law and a defense litigation practice group. She handles everything from inception of litigation and discovery to trial and post-trial motions. Additionally, Amy guides clients through the drafting of handbooks and day-to-day employment practices and decisions. Amy also conducts employment seminars, sessions and trainings, as well as investigations into workplace allegations of discrimination, retaliation, and harassment. Amy prepares employment contracts and agreements for clients and counsels private as well as municipal government clients on the employment obligations and assists in ensuring the compliance with federal and state employment laws. Amy is going to talk to us about how this affects us as employers, what our legal obligations are and rights, and I'm very excited to hear from both of them. So now I'm going to stop talking and hand it right over to Brittany. Thank you.
So I'm going to start out by giving a basic overview of the legal status of cannabis federally and in New Jersey, the permitting framework for cannabis businesses in New Jersey, and issues that are unique to the industry. The cannabis industry faces many unique challenges that are not faced by other businesses, and many of these challenges stem from the conflict between federal and state law. As we know, cannabis is still a Schedule I substance as of today, meaning along with what are considered the more dangerous street drugs such as heroin and LSD, and with the Controlled Substances Act, it's technically illegal to possess, manufacture, or distribute marijuana under federal law. Being a Schedule I drug means that it has a high potential for abuse. The drug has no currently accepted medical use and treatment in the United States, and there is a lack of accepted safety for use of the drug under medical supervision. So we are essentially in a paradigm where what is on the books is at odds with what we understand as reality. Obviously, many states have adopted medical cannabis programs and see the efficacy of use. Nonetheless, this is the law federally, and thanks to the Supremacy Clause, the federal law is the supreme law of the land, meaning that if there is a conflict between state and federal law, carries the day. And this is where a lot of the issues kind of plaguing the cannabis industry come from, this tension between federal and state law. Despite this, cannabis is becoming or has become pretty much mainstream. Recognizing the medical benefits of cannabis, in 1996, California defies federal law, and it's the first state to do so by passing the Compassionate Use Act that permits cultivation and use of medical marijuana. And since then, numerous states have joined in with California. As of today, we have 36 states, DC, Guam, Puerto Rico, and the Virgin Islands that have medical cannabis programs. And we have 17 states, 2 territories, DC, that have enacted legislation to regulate cannabis for adult use. Despite all of these programs popping up, the federal government has not taken action to legalize or remove cannabis from the Schedule I list, but has instead generally exercised prosecutorial discretion by not disturbing those that are acting in compliance with state law. The federal government had responded to these state programs with the issuance of 2 things that kind of eased some nerves in the cannabis industry, and these are the Cole Memo and the Rohrabacher-Blumenauer Amendment. Now, the Cole Memo is not law, but rather guidance, and this is a memo that was issued by the Department of Justice in 2013, which basically said, hey, we as the Department of Justice have limited resources, and we are not going to make going after marijuana offenses a priority unless they implicate one of 8 priorities. And these are kind of egregious things like preventing revenue from the sale of marijuana from going to criminal enterprises, gangs and cartels, and preventing state authorized marijuana activity from being used as a pretext for the trafficking of other illegal drugs or other illegal activity. The Cole Memo was rescinded by Attorney General Jeff Sessions in 2018. Sessions was not a fan of cannabis, but then his successor, William Barr, in a confirmation hearing stated that the Department of Justice was not going to go after marijuana businesses that were in compliance with state law. So that's the Cole Memo. We also have the Rohrabacher-Blumenauer Amendment, which is a provision in various spending bills that Congress has passed since 2014. And it says that no federal funds made available to the Department of Justice may be used to prevent states from implementing their own laws that authorize the use, distribution, possession, or cultivation of marijuana. This amendment is only applicable to medical cannabis programs. There has been a push for this to also be extended to adult use programs. But in general, just know that we're in a sort of paradigm where the federal government is taking a hands-off approach, provided there's compliance with state cannabis laws. In New Jersey, we've had a medical program. New Jersey has an operational medical cannabis program, and we will soon have an adult use marketplace. On January 18, 2010, Governor Corzine signs the Compassionate Use Medical Cannabis Act. But the very next day, Governor Chris Christie is sworn into office. And for the Christie administration, cannabis was not a priority, and the program somewhat stalls. But in general, this Compassionate Use Act established the framework for practitioners recommending cannabis, as well as the permitting process for alternative treatment centers. And those are your medical cannabis establishments in this state. They're known as alternative treatment centers. When Governor Murphy gets into office, cannabis is a priority for his administration. And on July 2nd, 2019, he signs the Jake Honig Compassionate Use Medical Cannabis Act, which reforms the medical cannabis program and greatly expands patient access. I won't go into everything that Jake's Law did, but notably it expands the list of qualifying medical conditions, really opening the door for a lot more patients to get involved in the program. It increases the 30-day dispensing limit from 2 ounces to 3 ounces. Weight limits would no longer apply to those that are terminally ill or who are currently receiving hospice care through a licensed hospice. It expands the methods of ingestion and so on. So this really kind of is where the program starts to pick up speed in New Jersey. Where are we now? We currently have 16 dispensaries that are operational statewide. There are over 1,250 practitioners participating in the program. There are approximately 106,000 patients enrolled in the program. And it's interesting to look at this number compared to the number when Governor Murphy initially took office. There was only about 17,000 patients. So you really see the expansion. At any given time in the state, we roughly have 20,000 pounds of cannabis or cannabis products in the inventory. And the Department of Health has issued biennial reports to show the need for lower prices and better value. If those who have been following the cannabis program, the Department of Health is no longer the state agency that is overseeing cannabis. It is now gone to the Cannabis Regulatory Commission as of this month. The Cannabis Regulatory Commission was actually established under Jake's Law, the expanded medical cannabis program in 2019, but it was just seated just this month. And we are still waiting on those regulations. So in general, you can see, although we only have 6 dispensaries, look at this number of patients, and we're soon to have adult use. The cannabis industry in New Jersey is really expanding. The reason we only have these, some very few dispensaries based on our need is because the state has so far only issued 3 requests for applications, or what's known as an RFA. So in New Jersey, we do not have a rolling basis where cannabis businesses can apply for a license. They have to wait for what is known as an RFA. The initial RFA was issued for vertically integrated ATCs in 2011. And a vertically integrated ATC, or alternative treatment center, is a cannabis establishment that takes care of everything in the supply chain from seed to sale. And then we had a 2018 RFA that added additional 6 vertically integrated ATCs. There was also a 2019 RFA released, which we are still waiting on the results for. If anyone has been following the news, there's been a decent amount of litigation between the 2018 and 2019 RFAs. The 2019 RFA was put on hold for a while. So we had many applicants applying for licenses to become cultivation entities, dispensaries, and vertically integrated ATCs in 2019 RFA, 2019 ATCs in the summer of 2019, and we are still waiting on those results as of today. On this year, on February 22nd, Governor Murphy signed the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. And this is what establishes the framework for adult use cannabis in the marketplace. Currently, there are no dispensaries that are operational in the adult use space just yet. The Cannabis Regulatory Commission has said that the medical program is still a priority for it, and the adult use program, cannot compromise the medical program. That being said, we are expecting, the adult use program to come up somewhat soon. We are expecting another RFA this year that will be administered by the newly seeded RFA. In general, the state is moving away from the vertically integrated model and more towards specialized individual functions. Like I said before, a vertically integrated ATC takes care of all functions in the supply chain. So they're trying to break it out where businesses can be more specialized. And so obviously we see here we have a cannabis cultivator license, manufacturer, wholesaler, distributor, retail, and delivery. So it is going to be more specialized. The currently functioning medical ATCs are going to have the ability to operate as cannabis establishments in the adult use market if they can meet 2 criteria. That is written approval from the municipality that they are in to enter into the adult use space, and they need to be able to demonstrate to the CRC that the business can sustain or has sufficient quantities of medical cannabis to serve the medical population. Again, the CRC is really trying to make sure that those quantities will be there so that the adult use program is not expanded at the expense of the medical patients. As of today, the CRC has not promulgated or adopted its regulations. We are waiting on those to come out. The CRC is supposed to begin accepting and processing license applications for adult use cannabis establishments within 30 days of the CRC's initial rules and regulations. And based on the timeline in the legislation, we're expecting the adoption of the regulations on or about August 22nd of this year. Kind of famously, the DOH has not met deadlines in the past always, so hopefully they are able to stick to what is in the law. And following the submission of a license application, the CRC is going to have 90 days to complete its review or determine whether more time is needed to review that application. If an application is approved, the CRC is to issue the license within 30 days after giving notice of the approval. A currently operational ATC that is approved by the CRC to operate as a retailer may begin to engage in the retail sale of cannabis on any date after the CRC's adoption of its rules and regulations, provided that those 2 criteria are met, those being the municipal approval and the certification to the CRC that the ATC has a sufficient sufficient cannabis quantity. So we are expecting those functioning ATCs, alternative treatment centers to be the first in the adult use space. The legislation does not place a numerical cap on the number of licenses available, with the exception of cannabis cultivators within the first 24 months following the enactment of the legislation. So that's going to be until February 22nd of 2023. Cannabis cultivators are going to be capped at 37 licenses, with the exception of micro businesses, which I'm going to get to in a second. Although there is no cap on licenses in the legislation itself, the CRC has the authority to determine the number of licenses for each class based on market demand. And I think that, you know, there possibly could be a cap placed by the CRC. I think they don't want to happen in New Jersey what has happened in some other states where the market is kind of overrun or has too much supply. They want to keep it competitive. During the initial 24-month period, so that's again until February 22nd of 2023, there is going to be a limitation on the number of classes of licenses that any one licensee may hold, kind of encouraging more entities to get into the space, so there's not, you know, just a few actors. Interestingly, I guess, and importantly, there is going to be a framework for what are known as conditional license and micro businesses. And these licenses are aimed at getting smaller businesses involved in the industry. Currently, we really have a lot of large multi-state operators. And I think that this administration's goal is to have more New Jersey in-state businesses getting involved and kind of opening this industry up for, you know, not these large, large operators in all these other states. So a conditional license is going to be available for individuals who may have relatively lower incomes and cannot immediately meet the conditions for licensure. And the qualifications include adjusted gross income of no more than $200,000 or $400,000 filing jointly. At least 30% of the licenses issued are going to be for these types of conditional licenses. There's also a framework for micro businesses, and these are, or at least these are supposed to be 10% of the licenses issued for each class of license must be issued to micro businesses, and at least 25% of the overall licenses must be issued to micro businesses. So if we go back to the slide looking at the different classes, in each of these classes, 10% is supposed to be reserved for these micro businesses, and it's going to be 25% overall for micros. But this has very strict criteria, and I'm going to be interested to see how the CRC actually deals with this, because 100% of the ownership needs to be held by New Jersey residents who've lived in the state for the past prior 2 years. At least 51% of the owners or directors must be residents of the municipality or neighboring municipality where the micro business is located. And that's kind of going to be a kicker. I'm going to talk about that in a second. And the micros cannot employ more than 10 people. There's going to be strict limits on the physical size and the amount of cannabis that can be held by a micro business. And they cannot operate in a space larger than 2,500 square feet. Again, with these micros, there's not supposed to be a cap on these types of licenses. But these are pretty strict criteria on what they have to meet. And there is a framework for a micro to eventually become a fully licensed cannabis business that does not have these sorts of limitations. There's also going to be priority consideration given to applicants with a significantly involved person residing in New Jersey for at least 5 years. Again, this is a push to get more, homegrown people into this industry. Priority consideration is also going to be given to applicants which are certified minority, women, and disabled veteran-owned businesses. The CRC's goal is to have 15% of new licenses issued to certified minority-owned businesses and at least 15% of new licenses issued to certified women or disabled veteran businesses. Priority consideration is also going to be given to applicants in impact zones, which are as with the definition of impact zones right now, I don't believe there are any impact zones that meet the criteria in Cape May County. These zones are areas where past criminal marijuana enterprises contributed to higher concentrations of law enforcement activity, unemployment, and poverty. And the criteria for an impact zone is very, very detailed. All right, so by way of, I guess this is probably one of the big rubbing points right now for the cannabis industry in New Jersey. Municipalities may enact ordinances governing the number of cannabis businesses as well as the location, manner, and times of operation. But delivery service times will be governed exclusively by the CRC. Municipalities have a 180-day period to opt out of having cannabis businesses within their borders. So that 180-day timeline began to run February 22nd of this year. And so those ordinances need to be done by, if a municipality is going to opt out, that opt out needs to happen by August 21st of 2021. Failure to enact an ordinance prohibiting cannabis establishments within the borders means that cannabis businesses will by default be permitted in certain zones. Municipalities may prohibit the operation of any one or more type of cannabis business, but may not prohibit delivery within the municipality. And as it stands right now, many municipalities are rushing to enact prohibiting ordinances in order to meet this deadline. And the idea is that, they can't, if they miss this deadline, they cannot enact another prohibiting ordinance for 5 years. Meaning that those default zones are going to be where these various cannabis establishments are going to be permitted. And the municipalities, a lot of them are going to take a wait and see approach, meaning that they're going to pass a prohibiting ordinance and then kind of see what's going on in other towns. And then maybe at one point they're going to jump back into the pool and allow it. The League of Municipalities has put out a sample prohibiting ordinance that a lot of municipalities are starting to adopt right now. There are other municipalities that are saying, we are open for business, and there is a reason why they want to be open for business, and that is the municipal transfer tax, which is really unique to the cannabis industry in New Jersey. A municipality may impose a separate local licensing or endorsement requirement as part of its restrictions on the number of cannabis businesses. So, a municipality can actually say, we only want this many dispensaries in the town. We don't want any growers in the town. We only want delivery in the town, those sorts of things. And like I said on the last slide, municipalities cannot prohibit delivery within their borders. So, cannabis is going to be in every town, whether the municipality likes it or not. It's just whether or not these establishments are going to be able to, set up shop. And if they do set up shop, a municipality may impose a transfer tax of up to 2% of receipts from sale by a cannabis cultivator, up to 2% of receipts from a sale by a cannabis manufacturer, up to 1% of receipts from a wholesaler, and up to 2% of sales from a retailer. So this is kind of to try to get municipalities to buy into the cannabis industry. By way of background, this has been an issue since the beginning of the cannabis program. After they passed the initial legislation in 2010, municipalities did not want cannabis businesses within their borders. So a lot of the initial ATCs had issues finding a home for themselves, essentially. So that's where we are right now. And so I would, keep an eye out in your towns as to what they're doing, because I'm sure this is planning boards are going nuts with this right now and trying to figure out, what they're doing. So I just wanted to briefly touch upon the issues that are currently facing the cannabis industry. Not go into too much detail on this, but for those that are interested in getting into the cannabis space, just know that because of that conflict between state and federal law, there are unique issues, and some of those are, banking issues. With the exception, there are very few banks that want anything to do with cannabis businesses. or cannabis businesses that derive funds from, that are secondary businesses that derive most of their funds from a cannabis enterprise. A lot of banks do not permit deposit accounts with marijuana-related businesses, and banks generally do not offer mortgages to these marijuana-related businesses. Financing generally comes from private equity, and that stems from the money laundering laws that we have in this country. If you have been paying attention to the news, the Safe Banking Act has passed the House again, but that's not the first time it's happened. It usually runs into problems when it gets into the Senate. And that would really kind of create a safe harbor from the money laundering laws for these banks, and maybe they would, that would be something that may encourage more banks to accept cannabis businesses. Unfortunately, cannabis businesses a lot of times are still functioning in cash, and that can create, somewhat of a dangerous condition with having that much cash on site. So that's something to be mindful of. Because again, it's still, cannabis is a Schedule I substance. So it's deterred a lot of insurance companies from entering into the cannabis industry. Insurance companies also need to, follow federal law. And so a lot of them have not really come into the space. There's no safe harbor, but no federal action has taken place against insurance companies so far. But these cannabis businesses still need insurance for a variety of things, including product liability, property insurance, commercial general liability, workers' comp. Specialty coverage such as crop coverage and IP coverage has really been difficult to come by. Traditional property insurance is not going to cover crop loss. So for growers, property insurance will cover grow facilities. In general, there is unfavorable tax treatment for the cannabis industry. IRC 280E prohibits all business deductions or credits to persons in business trafficking and controlled substances. So, if you're a business and you can't deduct your expenses, that can be a problem for your bottom line. So that's another thing to be mindful of. We already talked about zoning and land use and how cannabis businesses kind of have had difficulty finding a home with different towns, and they are ineligible for bankruptcy. All right, so that's your overview of my portion. So I'm going to stop sharing my screen. And
Brittany, that was wonderful. Thank you so much. I really appreciate it. I know I learned a few things that I didn't know that was connected to this law. And I know there's so much to still unpack. And next, we're going to turn it over to Amy, who's going to talk to us about how this affects us as employers. And I just want to remind everybody that if you have a question, please put it in the chat and we'll save time for questions and answers at the end.
Thank you, Katie. And thank you, Brittany, for that overview. That was very interesting. I think when this passed on the vote, I doubt anybody realized the complexity of the laws that we're going to go into it and the framework that we'd be dealing with as growers and cultivators, et cetera. So I'm going to stop my video and share as well. I have a PowerPoint too. And while I'm getting this up and running, it occurred to me that we had an enormous missed opportunity in doing this on 4/21 as opposed to 4/20, because here we are a day late, and wouldn't that have been so timely if we had done this yesterday? So can everybody see my screen?
Yes, we can see it.
Okay, excellent. Okay, super. So I'm sure that the big question that everyone is asking is, are my employees allowed to smoke pot at work? And you might be on this Zoom just to get that answer to this question. I'm going to go through what you are and are not allowed to police at your workplace. And lots of statutory things get a little wordy and a little dense, but I'm going to make it as easy as possible. So for hiring policies, you're not allowed to discriminate on adult users just for being an adult user. And so as Brittany went over, Governor Murphy signed into law the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. And so under this act, you'll see that they've actually created a whole new specialty of experts. I'll talk about that briefly too. But I think we need someone who works for the state who works on acronyms because these are really getting a little bit ridiculous. I think it should be the same person who maybe names nail polishes because they seem to do a nice job. So I'm not sure what people are going to call this. I want to call it New Jersey Crema, but that sounds ridiculous. So we'll see. This law addresses many aspects of the now legalized practice of cannabis use in New Jersey for recreational reasons. And it also addresses some employer concerns over recreational use. The law specifically prohibits employers from refusing to hire, from terminating, and from taking other adverse action against employees based on their cannabis use. I'm not talking about use at work, I'm talking about their general use. Specifically, they define adverse action, which generally in the employment law world, we have a fair understanding of what that means, but employers sometimes get confused about it. And so it does mean under this law, you can't refuse to hire someone, you can't fire someone, you can't require an individual to retire or otherwise discriminate against them in terms of their conditions, privileges, or compensation during their employment. And this is for all employees without regard to their job classifications or the nature of their job duties and responsibilities. So we've seen in other statutes where we are allowed to do certain things when it comes to safety positions. If we were in a especially safeguarding role, like a teacher or someone who oversees children or someone who operates heavy machinery, sometimes we're allowed to put greater imposition of restrictions on those employees, and not per this statute. So that's a really interesting take that the state government has made on this. Essentially, what we've been hearing is that they are affording adult users protected status class under New Jersey law, which is for employment practitioners a big deal. So drug-free workplace policies. This does not change the drug-free workplace policies, and employers are not required to allow the use of cannabis in the workplace. So you can still say that no one is allowed to possess or utilize marijuana products during work. And you're also not allowed, you are allowed to have a policy that prohibits people from being under the influence at work. So that leads us to, how are we going to be policing people who are under the influence of marijuana? So drug testing under this act, an employer may require employees to submit to drug tests in the following circumstances. So number one, if the employer is suspicious that the employee used cannabis while engaged in the performance of their work. Number two, if the employer observes signs of intoxication related to cannabis use. And number three, following a work-related accident. So as far as employers, this really isn't all that different from how you've probably been policing alcohol in the workplace. You don't allow alcohol at the workplace. If you observe signs of intoxication, you react to it. And if there's a work-related accident, then you would investigate that as well. So drug testing requirements. The Act really does discuss how to go about drug testing, and Brittany and I spoke about this yesterday in the office. One of my questions initially is, I thought, my vague recollection from everybody's rumor mill in college was that marijuana stayed in your system for a really long time. I couldn't remember precisely, but how are we going to be testing people if this is going to be hanging around in their system? If there's a suspicion of use at work and you test them, then it might be in their system from 3 weeks ago. And so the Act has tried to anticipate that problem, and apparently the rumor I heard in college is a real problem. So the drug testing requirements, they're required to include scientifically reliable objective testing methods and procedures. So that would be blood, urine, and saliva, as well as an impairment evaluation by a certified workplace impairment recognition expert. And so that's when I alluded to the creation of a new job or a new job classification. Workplace impairment recognition expert is something I've never heard of before. And so that's something that we will see new individuals entering into that world and going through the certification process to become such impairment experts. Employers may continue to require random testing or testing as part of their pre-employment screening or regular screening of their current employees to determine use. And they could use the results of such drug tests when determining appropriate employment action. But once again, the results may not factor into the hiring decision itself. The Police Training Commission is going to be working in consultation with respect to the standards, the minimum curriculum courses of study, the approval of private programs, organizations, and schools, and instructors to offer this workplace impairment recognition expert certification. And so as an employer, what I hear when I hear about this is I hear that this is going to cost us money, because when we have a suspected use, we're going to have to be hiring this person, or we could internally certify someone at our own office. And I think that's the most prudent thing to do, is to quickly get someone certified in that ability so as to avoid the necessity of hiring someone out. A lot of that we're going to have to wait and see how these courses go and see how onerous it is to become certified. Reasonable accommodation policies. I'm going to go over each of these. Because cannabis remains illegal under federal law, this act doesn't really have any interaction with the federal laws, such as the Americans with Disabilities Act. The J. Koenig Act that Brittany talked about before outlines policies and procedures for employees who possess medical marijuana cards and have reasonable accommodations associated with their medicinal cannabis. This act doesn't necessarily address the reasonable accommodations any further. It remains employers are not prohibited from taking adverse action against employees who possess or use intoxicating substances during their work hours. So whether you have a reasonable accommodation policy allowing individuals to have marijuana in their system, they're still not allowed to use it at work. And this law did not change that. Additionally, that act did not require that an employer take any action that would cause them to be in violation of federal law. So as an employer, some of you are federal contractors and have to comply with federal laws, or you have federal licensing for truck drivers, et cetera. This doesn't change that. There's no alteration. You must comply with the federal law, and your obligations there will protect you from claims under this act. So private versus public business distinctions. There's really a lack of boundaries between the differing treatment of public and private businesses in the act. They seem so far to be subject to this equally. And there is a carve out, for employers that are federal contractors. So, and this is what I was speaking about before, if the law requirements would result in a provable adverse impact on an employer subject to the requirements of a federal contract, then the employer may revise their employee prohibitions consistent with federal law, rules, and regulations. And that language is right from the act. The provision would also include employers who are subject to the DOT drug testing requirements for safety-sensitive positions, which currently prohibit the use of cannabis. So as a result, federal contractor employers are generally permitted to take adverse employment action against their employees who test positive for cannabis use without any further evidence of misconduct. So you don't have to wait for an accident. You can still have a no drug use policy on or off premises. For interaction with disability laws, we have this is really the 3 New Jersey marijuana laws, and Brittany went over them in pretty great detail. The New Jersey Supreme Court recently held that this new statute obligates employers to accommodate, the previous statute, the Honig statute, obligates employers to accommodate an employee's lawful use of medical cannabis outside of the workplace. So I did talk about that a little bit already. You cannot discriminate against someone who was using their medicinal marijuana outside of the workplace to treat their medical condition or their disability. And again, in the 2019 Act, we have expanded protections for employees who are using their medicinal cannabis, including their job protection and testing procedures. It specifically states it shall be unlawful to take any adverse employment action against an employee who is a registered qualifying patient based solely on their status as a medical cannabis registrant. And employers are required to provide notice to employees who test positive during their drug test. Those employees then have 3 days to produce evidence that they are a medicinal cannabis user. So if you did test someone, the test comes back positive, you've never heard anything about them being a medicinal user, you must give them the 3 days to prove it to you that they are. The new act requires an employer to amend or repeal or affect, restrict, or preempt the rights and obligations of employers to maintain a drug and alcohol-free workplace or require an employer to permit or accommodate the use. Excuse me, nothing in the act requires this. And so I skipped over that word in the beginning of the statute. Really, you can have a drug-free workplace, but you're not going to be able to police the outside activities of your employees. And so really, this is how we've been treating our alcohol use as well for years, probably since the creation of employers and employees. We've had employees who drink outside the workplace and employees who drink at the workplace, and we've been policing that. So this really shouldn't be as hard as everyone is making it out to be. The most difficult part of this newest statute is going to be the certification process and making decisions with respect to who and who is not under the influence. As an employment attorney, my biggest concern is discriminatory treatment of individuals. So suspicions on more individuals of one particular other protected class rather than individuals of a majority protected class. So if the suspicions are focused on individuals who are minority race, for example, and you're testing them and their tests are coming back clean, and majority employees are never being tested, I anticipate that we'll see some discrimination claims under that. Otherwise, the regulations are going to be certainly interesting, but the legislation itself is pretty comprehensive. And so they've given us a lot to work with here, as well as a lot of TBDs, including that certification process. I kind of tried to buzz through this quickly, as important as it is. I know I wanted to save time for questions because I'm sure that's why a lot of people have joined us today. I'm going to stop my share and turn my camera back on, and that way we can be ready for anything that anybody has to ask. Thank you.
Thank you so much, Amy. That was wonderful. And I do have a question, so I'll start.
Sure.
We are federally funded in part. So I have a community nonprofit that has federal funds and obviously a drug-free workplace. So if we do periodic drug testing, does that mean that my staff cannot use cannabis?
If your federal contract or your federal agreement requires that you maintain a drug-free workplace,
It does.
then yes.
So that's very important. So anyone whose federal funding requires a drug-free workplace means that those staff, if they are drug tested, need to abide by the federal level, not the state level.
That is the position that we're taking until we have some more of the regulations. That is what the statute's saying.
Great, thank you. And then the other question I had was around CDLs, which you touched on. So if there is a overarching licensure that you have, like a CDL, or if that your staff have, they have to maintain the drug policies related to those as well, correct?
Exactly, yes. So this is when I know sometimes lawyers get lost in the weeds of the laws, and we think that's terribly interesting and everybody else thinks that's boring. But this is where the supremacy clause really comes in, so that the federal law trumps the state law. So the state can regulate that with which is in its boundaries, except where the federal law gets involved. And so there the federal law wins. So if you're an employer and you have any sort of obligation to the federal government, your obligation stands. And if you have a contract with the federal government in terms of funds, you must maintain the requirements of that contract.
So for companies that have different types of employees, they would almost have they would need to have different policies in place for the different types of employees, whether they're safety or non-safety?
It's possible. It's possible that if they don't receive federal funding, but they do have federal licensure because they have drivers, that they would have then different rules for different individuals. What's going to be even more complicated, and we see this in lots of laws, is state or employers who operate in many states. And so I often get calls from employers who say, all right, we have 6 locations and they're in 6 different states, and can you help us draft our policies? And I kind of laugh because I can help you draft 6 different policies, but it's unlikely that we're going to be able to draft one policy that's a one size fits all.
That makes a lot of sense. And speaking of policies, the one question that has come up in the chat so far is, has anyone prepared or have a policy in place? Someone would love some direction on that. And from what I heard you say, that if you have a drug-free workplace policy, that can stand. So if you have an existing drug-free workplace policy, that's still appropriate. However, the proof is the burden of the employer in terms of if they are using cannabis or any other substance during working hours.
So exactly, the drug-free workplace policies probably don't say anything about smoking pot on Saturday, and that is not changing with this law. I can't imagine, and I've never seen a policy that says you are not permitted to use marijuana on the weekend or in your off hours. And really, I don't think it's going to involve a lot of changing of our workplace policies. The drug-free policy, that's going to stand. But you can maintain your drug-free workplace requirements. And this really comes down to, if someone takes a smoke break, are they going to be allowed to take a marijuana break? No, you can have a drug-free workplace and prohibit the use during working hours. So no marijuana breaks. It's not the same thing as smoking.
And just to circle back on what you were saying previously about drug testing, you are 100% right. I know this as because of what we do in the community as a counseling agency. Drug testing will not tell you when someone used any type of cannabis. The levels would be similar within a couple of days.
Yeah,
so your college
exactly.
self was right. That's
yeah. That was the rumor through my sorority. I never fact checked it, but excellent. I saw a question come in, and I don't know the answer to it with respect to public schools. I think this is something we're going to have to wait for the regulations. I don't know if the schools are going to be able to pass a complete bar to off-hour recreational use. And that's something that I didn't specifically look into. It might even be answered, but it's a really great question. And I'm happy to look into it and get back to the question asker, but it's not something that I have checked.
I think if the student is under 18, you have some wiggle room about what you can say is on their possession at school and on school premises. If they're under 18, because you're saying students as well, but you're right about employees. I do not know.
And use is different than possession. So yes, you can definitely ban possession for everyone. You can have a drug-free workplace. No one is allowed to possess any implements for marijuana use or marijuana itself at the workplace. But are they allowed to, are teachers allowed to utilize marijuana on the weekends and not be and come to work not under the influence on Monday because of the federal funding? That's what I don't know the answer to. So we'll have to look into that. Yeah, the interesting question is going to be for the boardwalk employers, which I know you have plenty, is what do you do with the 17-year-olds? So these are not adult users, these are child users. And that's something that we're gonna have to look for the police, and I haven't dabbled into this a whole lot, but the police have been issuing their statements as to what they will and won't do in my own town. They gave a little statement about what they will and won't do for juvenile use. And that's the situation the employers on the boardwalk with these kids are going to be in. I would defer to the police and see how they want to treat it.
Amy, I have a quick question.
Sure.
So right when Katie had posed her question about the CDL drivers and such, my equipment decided to cut out and I had to sign back into the meeting. So I awesomely missed that one part of information that I needed to get. Could you go over that again for me?
Sure. Absolutely. So for CDL drivers, part of the requirement is that they are subject to random testing and they are not permitted to use at all. And that stands. So that's a situation where the federal law trumps the state, that if they want to continue to have the privilege of the federal licensing, then they have to continue to operate pursuant to the federal law.
Okay,
So there's no change there. This state law doesn't trump that.
would it be clear for me to understand that if the employee perhaps loses their commercial driver's license based on they decided to get the medical marijuana card, then we could release them as an employee because they no longer possess the commercial driver's license?
So for employment law, the answer always starts with it depends. I'll assume it's a small business for the purposes of this question, and that there are no other jobs for this person. Okay, so there's really probably nothing else that this individual can do for the workplace. That would be ultimately the question. Can they be accommodated in some other position for purposes of their medicinal use? They lost their license. It's not that you caught them using at work. It's that they, tested hot on a random test for the DOT. That's going to be an interesting situation that we're going to find ourselves in quite a bit, I think. But there, you'd likely be safe terminating because they can no longer do the functions of their position. They lost the license, which is why you had them.
Okay, well, I appreciate your comments. I mean, I don't expect that to occur, but if things transpire and we come across that, I'm going to have to probably, do some legal counsel review before we act on termination or anything and take it from there. But thank you for your answer.
Oh, you're welcome. The problem with employment law issues is that no matter how solid your position is as an employer, you might get sued anyway. And so if the advice ends up being, oh yes, you're safe to do that, you still could find yourself facing a lawsuit. You were safe to do that, but you have to prove it if someone brings the law, and they have the burden of proof. So, but you'd still have to put up your own proof.
I don't see any more questions in the chat. You can also use the raised hand feature. Oh, I see. No, it's not a raised hand. You can also use the raised hand feature if you'd like to ask your question directly. So we'll give that another couple of minutes if someone's thinking about something they want to ask one of our presenters. And Katie has placed a link to get more information. So you may want to grab that as well. Katie,
while we wait for a second, Vicki, there was another part of the one question about the schools that was what amount is considered needed to be under the influence. And that really goes to the analysis of the individual who ends up being certified through that certification process. So it's not going to be an amount as much as it's going to be a review of the symptoms. So similar to alcohol, some people can have, 10 drinks and not show the symptoms of someone else who might have 2 drinks. So it's going to end up coming down to that certified person who follows the criteria set through that process.
Thank you, Amy. So the link I put in is a link to SAMHSA, which is the Substance Abuse and Mental Health Administration. It's a federal organization that focuses on mental health and substance use nationally. That link will take you to a web page that is a workplace toolkit. It will help you do an assessment of your organization in terms of how many people and what appropriate policies are. They are generic policies, so I would just caution you to make sure that you are reading it, make sure whatever you adopt works for you. And that's where the wonderful Amy might come into play with another conversation. Or you can always reach out to Keep Assist for more information. And it looks like we have a few more questions. Christina would like to know, do any insurance companies on here have any input? Do we have any insurance companies represented here today? Maybe that's a question that the chamber could circle to some of their members and then get back to us on. And then Mike would like to know, can you share the PowerPoint slides? They'll be very useful when speaking to their department heads. I don't know if that's something that the speakers are comfortable with.
Yes.
Sure.
Wonderful.
we will send those out.
Thank you. I took a couple pictures myself, especially of the types of businesses, because I don't have that written down anywhere. So that was great for me to see labeled out so perfectly.
Katie, I guess it would make sense to email the slideshow or the PowerPoint to the chamber and then they could distribute them, or
Please.
I wonder the most effective way of doing that.
Yes, if you would send them to us at the chamber, Amy and Brittany, that would be great. And we will send it out to everyone who registered for today's program. Thank you.
Thank you.
Okay, well, I'm not seeing any other comments or questions in the chat, and I don't see any raised hands. I would just like to thank Amy and Brittany and Katie again for such a great informative program today. And all of you for joining today. Your questions were very thoughtful and very insightful. Thank you for that as well. And we'll get all the follow-up information to you. I'm sure that this is the first of more information to come from the chamber on cannabis and how it will affect us in the workplace. I would also like to invite everyone to join us for our webinar tomorrow at 12:30 for social media marketing, sponsored and presented by Allegra Marketing Print and Mail. And then next week, we have another full agenda. We have a program provided by NJEDA on the Phase 4 Small Business Grant Program opportunity. And then that's on Tuesday. On Wednesday, the SBA will present a program on the Restaurant Revitalization Program. And then on Thursday, COVID-19 impact on the Cape May County economy, presented by Dr. Oliver Cook with Stockton University. So again, next week, another full agenda of programming by the Cape May County Chamber, and you can register for any and all of those on our website, capemaycountychamber.com/events. So thank you, everyone. Have a wonderful day. Again, another special thank you to our presenters, Cape Assist for sponsoring, and Cooper Levinson for sharing all your wonderful expertise. Amy, Brittany, Katie, everyone, have a great day.